Greetings.
Hi, Wes.
Howdy. Happy Friday.
Thank you. You too.
Where's Brady, Lucy?
He'll be home any minute.
Right. I hope you all have a happy Father's Day.
Thank you. Likewise.
We're having Armenian food.
Cool. There. Oh, can you hear me now?
I can hear well, yeah, I can hear you.
Okay, good. Okay, thanks.
Leda, hello.
Hi there. I apologize. I'm not ready for prime time today. So as much as I'd like to participate, I'm gonna be kind of quiet.
Okay, fair enough.
Wes, you look like you're in a church or a courtroom.
Courtroom. Let's see what options I have.
There, I can hear you better now. That's nice.
Is that better?
Yeah, that's lovely.
Everybody's going to Hawaii all of a sudden. I know several people have gone to Hawaii.
That's interesting.
Maybe they have cheap flights.
I was gonna say, because it's pretty expensive there. I don't know.
There's another trustee, Larry Simons, who's on the Big Island right now. And I was suggesting that he go visit the sanctuary, which obviously has a lot of legal significance for lawyers. Has anybody here ever been to the sanctuary on the Big Island? It's a state park. And under Hawaiian law, if you murdered someone and you were able to get to the sanctuary before the victim's relatives did, you could live at the sanctuary unmolested forever.
Wow.
Surviving on fish,
Wow.
fresh water, and whatever else wandered by, I guess. So
Wow.
kind of an interesting concept.
Yeah, because you're still imprisoned, but it's more like house arrest in a nice, beautiful place.
Yes, it's as I recall, it's a couple of acres, so I guess you
Oh, wow.
you could
Pretty
just live there and try to figure out a way out, try to build a boat like Gilligan's Island or something.
Oh,
Right?
there you go.
And it doesn't cost the state any money.
Oh, no. I was telling him there are a few things more delightful than having breakfast on the Big Island, outside and people watching. It's fun.
Yeah, Hawaii's lovely.
Okay, why don't we get started? Today we are talking about debtor eligibility and the different forms of bankruptcy relief. We're talking about Chapter 5. And liquidation under chapter, I'm on page 114. Liquidation under Chapter 7 aims at the surrender and dissolution of the debtor's executable estate for the purposes of generating a fund to be applied to the payment of creditors. On the other hand, chapters 11 and 13 each have their own rules and principles, and they look at rehabilitation instead of liquidation. As a general yardstick, I'm on page 115. As a general yardstick, one can say that the premise of the code is the value received by creditors under the plan must be at least equal to the present value of what creditors would have received if the debtor liquidated under Chapter 7. So, my exposure to Chapter 13 is limited. typically it's someone coming in from chapter 13 or trying to escape me by converting out. Are zero payment chapter 13 plans common in your experience, or do you consider them quite rare? Clifford?
Never seen
Yeah,
that.
I think they're pretty common.
Yeah?
Yes. Usually if
So-
somebody has a barely feasible plan and they're trying to catch up mortgage arrears or taxes,
You think the courts are sympathetic to that?
well, I think the court will allow it. There's nothing in the code that prohibits it. If the plan is otherwise meets the best efforts test and the liquidation test.
In your experience, will chapter 13 trustees second guess a debtor's valuation of her home?
They will, yeah, they'll ask at least for some documentation of it.
Have you ever seen it challenged? I don't think I've ever seen that.
By a trustee.
By a chapter 13 trustee, yeah.
I don't think I've ever seen it challenged. No, I don't think I've seen that. I've seen it informally negotiated, but not through a court process.
Danielle, have you ever seen that? I think you're on mute. I think you're still on mute.
No, I haven't ever had it really challenged. I have had a trustee ask me for proof. And I've gone back and forth, so the negotiation process, but not formally challenged for me.
I guess this is an example of the difference between chapter 7 and chapter 13. In that in chapter 13, I think the estate as presented by the debtor is accepted largely, whereas in chapter 7 that is completely the opposite. I can tell you as a chapter 7 trustee, the fact that a debtor lists a claim as secured in my eyes doesn't make it secured, and vice versa. So, I mean, you completely analyze everything, from the top down. Value, liens, disposition, etc. Whereas in chapter 13 and initially in chapter 11, there's this orientation that the debtor is in charge, and we're going to see if he or she can rehabilitate. Any comments on that?
That's been my experience. It's usually considered more about the debtor's income than their assets, and making sure that they're paying a sufficient percentage of their income based on their ability to pay.
Now, I agree with you. I think chapter 13 trustees do get into the weeds on that. In other words, looking at expenses, looking at schedules I and J, and analyzing what can they pay. I agree, they do get into that. Okay, moving along. Let's see, let's go to 116. This is something that, in other words, what is a person? What is an individual? This is something that typically there's a multiple choice question on. A person obviously can be an individual, a partnership, or a corporation. An individual is a living person. I don't know if we've covered this in the past, but people who are dead can't file for bankruptcy. So, and probate estates are not eligible for bankruptcy. Looking at page 117, something I guess I hadn't come across is that bankruptcy courts consider limited liability partnerships to be corporations, not partnerships. Any comments on that? In other words, it's a corporation in the bankruptcy court's view because there is some kind of limited liability of the owners, just like with a corporation. So, has anybody had any experience on the filing for bankruptcy by trusts, trust filing for bankruptcy? Does anybody know the rule on that?
Can file for a business trust.
Very good, very good. You get an A plus on that. So, trusts, other than business trusts, are not eligible to file for bankruptcy. So, if a house is in foreclosure and it's held by a trust, the trust can't file for bankruptcy. So, Tinho, what is a business trust?
My understanding of that is it's sort of mushy, but it's basically a trust that operates a business.
The cases I've seen are Massachusetts cases, and are a function of Massachusetts law. I think that has some kind of, a business trust has some kind of specific meaning in Massachusetts, but go ahead.
Haven't looked at it too much other than my general understanding is that it's a trust that's principal purpose is operating a business versus, sometimes people have their ownership of a business in their personal revocable trust, but that's their personal trust that holds their stuff. It's not a business trust. That's the extent to which I've analyzed it.
In my career, I've had this issue once in 33 years. I've come across where this was litigated. And I think they're going to start looking at books and records, who are the beneficiaries, in terms of eligibility for relief. Let's see. How often, those of you who represent, you mainly have debtor practices, how often do you run into situations where you have a deadlock in ownership of a corporation such that you're not able to file? Mark, have you hit that?
I've never hit that. Most of my corporate filings have been small corporations with one or two or three shareholders, and but I don't think the shareholders vote on whether to file or not. I think it's the directors, right?
Right, but I'm saying if you have two directors.
Yeah, I've never run across a deadlock.
Anyone?
My experience is that the more aggressive, shall we say, party interested in filing will just do it and find a way to justify it. That's how we roll in South Florida.
I think that's one view. Bankruptcy is not for the faint-hearted, but you always wonder about sanctions and drawing the wrong judge, doing something with an unauthorized petition. Obviously, if you've got a deadlock, the answer is state court, get a receiver, and then do a corporate dissolution through state court. Okay, I'm on page 118 now. And we're getting into consumer versus business debtors. And the book points out the only time this really arises is with consumer debt, which is defined in section 101(8), which describes a consumer debt as one incurred by an individual primarily for a personal, family, or household purpose. From this, it is clear that one should not simply equate individual and consumer debtors. An individual is not a consumer debtor unless the bulk of the person's debt is incurred in the course of domestic consumption. With regards to taxes, let's see, Tinho, what is the rule on whether a tax is a consumer debt or not? Is it how it was generated, how the liability was created?
I would only be guessing if I tried to answer this question. So I think I will
Go
refrain.
ahead and guess.
Okay. My guess is it's a business debt if the tax arises out of the non-income related pieces of a business. For example, payroll tax or a sales tax.
In other words, if you work for a wage, it's always going to be a consumer debt.
Okay.
Whereas if you have a business, then I think it's in play. This comes into chapter 12, obviously, chapter 12 eligibility. But I think what we're talking about here is a means test.
Wes,
Go
on
ahead.
on that issue, I think in the Ninth Circuit, taxes are always.
Yeah,
Go ahead.
that's what I thought.
So the
Or-
distinction isn't really, everybody makes the mistake, I think, that says business or consumer. The reality is it's either consumer or non-consumer. And so non-consumer is taxes in the Ninth Circuit. I had a client that rode his motorcycle in the desert at high speed. Last thing I remember is going over a jump and then waking up 6 months later. All of his hospital bills were non-consumer because he did not have the intent to create the bills. They did his operations and kept him in the hospital without his knowledge, without him acquiescing, okay, or having knowledge that he was incurring the debt. So it really goes to the intent. And if there was,
Michael, can you go back a couple steps? This is interesting.
sure. So,
Go ahead.
so really, we look to the intent of the debtor in the Ninth Circuit. So taxes are automatically created. The debt is automatically created. So there was no intent to create the debt, so it becomes non-consumer. So for the purposes of getting around the means test, you have to do your T-chart, and you do consumer versus non-consumer, and you look to the intent. And you can even be a home loan if you can demonstrate that a portion of the loan was taken out and put into the business. So if you have a debtor that borrowed against their house and 50,000 went to pay off credit cards and 300,000 went to fund the business, we T-chart that into 300,000 toward non-consumer.
Okay.
It's just, that may be different in different circuits though, Wes. I don't know, other than the Ninth.
Have you argued this with the U.S. Trustee's office?
The argument I had with the U.S. Trustee's office was in Riverside, and they're particularly aggressive out there, and that was the motorcycle case. But when they saw his hospital records and realized that he was just receiving treatment, but he was in a coma, that they said, you're right, he had no intent, and they just moved on.
Christy, did you have something to say on this issue?
Oh, I was thinking the same thing, that taxes are considered non-consumer debt in our district. That's what that was my impression.
Okay. Let's see. How often, I'm on page 120, how often do you get prospective clients who call you up and say, I represent an entity that's got a 109 bar on refiling for 6 months. How can I get around this? I've gotten those calls with you. Mark?
Yeah, I've had that question, and
Hmm.
it depends on a lot of circumstances, and I judge the credibility of the person asking me that question. Most of the time I end up telling them they gotta wait.
Any other thoughts? Is this a question of know your judge?
Not for me, because I don't know that, I usually don't know the judge before I get them, if I were to refile. So no. Do you mean in a motion to reopen a case that was closed and barred?
No, I'm saying, I don't know how many of you do it, but in terms of, like, for example, Santa Ana, there aren't that many judges. So you could kind of gain this. For example, I think that one judge might be more open to a debtor's plight than others, and would be okay with a transfer of assets and then a new filing, more so than other judges would be.
Hey, Wes, can I ask you a question on that?
Right.
And so Mark and everybody here, I've done that in the past, and I'm a cynic after doing this for 30 years. But, I don't know why, but I think one of the bigger factors is when somebody contacts you like that, you say, well, who was your prior counsel? And if you know that the prior counsel is solid, that in my mind is almost a deal killer. But
Right.
if they went to somebody and you look at the docket and you look at communications and the other attorney just didn't communicate with them and it's clearly the other attorney's fault, I'd feel more comfortable in taking a stab at getting that bar removed.
I agree with you. Whenever this comes across my desk, though, it's typically a solid attorney that I know. Plus, now you're inheriting a case where the principal doesn't pay her attorneys, you know, which isn't good. Okay, moving along. I'm on page 128, and we're talking about Chapter 7 eligibility. Chapter 7 relief is widely available. Anyone who may be a debtor under the code may be a debtor under Chapter 7 except for railroads, insurance companies, and various kinds of banking and investment institutions. We had a very famous case at my initial law firm where we had a rainmaker paired with an attorney whose main focus was working out at noon, and it was like a lethal combination. And what they did was they filed bankruptcy for an insurance company in receivership. Well, that had two problems. Problem number one is that insurance companies can't file for bankruptcy. And number two, the principal had lost power to do so once it was in receivership. The case was dismissed. They appealed to the district court. Was it dismissed again? They appealed to the Ninth Circuit. And then my firm was whacked with hundreds and hundreds of thousands of dollars in sanctions.
Mm.
So, let's see. Going back to consumer debt, so though 109B provides for Chapter 7 eligibility is subject to an important qualification under 707B, whether debtors individual whose primary debts are consumer debts, 707B is amended, requires the court to dismiss Chapter 7 if it finds that the granting of relief will be an abuse of Chapter 7. Abuse is presumed under 707B if an individual consumer debtor has disposable income deemed sufficient to make payments under a Chapter 13 plan. In my district, the only people that police this are U.S. Trustee's office. Anybody have any different thoughts?
I think I've had Chapter 7 trustees get into Schedule I and J before.
Really?
Yeah.
That's
Yeah.
amazing.
Yeah.
I bet I could guess. Certainly wasn't me, but I bet I could guess who that was.
I observed a hearing either this week or last week in front of a judge where a creditor had brought a motion to dismiss under 707B, but as it's 707, the B6 says only the judge or United States trustee may file such a motion. And so the person who suggested they were going to file that got severely scolded. But there's no motion in front of the court. It's just like, well, the statute says this, so these are the only people who are supposed to care.
I think it's a rare occurrence.
I thought,
Okay. Go
I
ahead.
thought 7B actually says any party in interest could,
Mike, what are you looking at?
707B, I thought any party in interest could pursue a dismissal of the case under 707B. And the big fear for consumer attorneys, I did a presentation on this back when the law passed, is that if you, as an attorney, don't do your due diligence and it's found that you should have known better than to file that Chapter 7 for the debtor, you end up paying the attorney's fees for the creditor or whomever was successful in getting the case dismissed or converted. So if I read it correctly, it says, or any party in interest may dismiss a case.
Have you ever seen that? where attorney's fees or an award of attorney's fees are given to the movement.
Thank God, no,
I've never seen.
not once, not once. But you know, I don't want to be the first case, Wes.
All right, we're now moving over to my favorite subject. As a chapter 7 trustee, I'm on the bottom of page 129. We're looking at chapter 13 eligibility. Section 109E sets out 3 distinct qualifications for eligibility. The debtor must be an individual, the debtor must have regular income, and the debtor's total debt at the time of filing must not exceed the prescribed limit. Now, an individual with regular income is defined by 10130 to mean an individual whose income is sufficiently stable and regular to enable such individual to make payments under a plan under Chapter 13. This is critical. Section 109 does not state the date on which regular income requirements must be measured. The date of filing is pertinent, but some courts are willing to consider the issue prospectively, so that even if the who does not have regular income at the time of filing could be eligible if there's a good prospect that the debtor will have regular income at the time for payments under the plan arrives. Any thoughts or experience on that? I've got lots and lots of experience on that. Cliff?
In my experience, it's never an issue. If there's some plausible way to fund a plan, regular income is not usually an obstacle, even if it's funded with a contribution or, you know, a prospective business venture. You know, unless it's really highly speculative, I haven't seen a Chapter 13 trustee object if the payments are being made and the plan is otherwise feasible. And
How about if they're in Chapter 7 and they want to convert under 706A, and the question is whether they have regular income?
that would probably be more of an issue, I would imagine.
Often, to avoid any kind of means test issue, you know, there's usually a deficit on I and J. So when an unscheduled asset is uncovered, obviously one of the first things they're going to try to do is amend I and J, and then you get all this phantom income coming in. It's been my experience that if you have declarations, if the debtor seeking to convert has declarations from family members saying that they will contribute X dollars over the length of a plan, the judge is going to buy it.
I've had that.
So Chapter 7, so long as, especially if they're going to pay all claims in full, Chapter 7 trustees out of business. Any thoughts on that?
Wes, I have a question about your comment earlier about that you have some Chapter 7 debtors that run to you to go to Chapter 13. So my general inquiry is, as trustee or trustees counsel, how do you address those? Do you make sure admin fee is paid, or how do you protect yourself as a 7 trustee in those scenarios?
Okay, well, let's see. First of all, there's kind of an etiquette issue and a legal issue. But Chapter 7 trustees are supposed to be paid on your distribution. So if your distribution is 0, you are paid 0. There's also kind of an etiquette issue that whereas your attorney can get paid, you're out. So if, you know, next case for the Chapter 7 trustee. However, in my case, what we do is we set up language that there's an automatic reconversion to Chapter 7 if the plan fails or if dismissal is filed.
That's
The only
clever.
problem with, go ahead, Christy, and then I have something else to
Oh,
say.
I was just saying that's clever. That's all. Sorry.
Well, the only problem with that is it doesn't work,
Oh,
because the Chapter 13 trustee just dismisses it, bang. She doesn't look at what the order said, convert, they just, so the Chapter 7 trustee has to be on top of it forever, and then get the case back, and hopefully the asset hasn't dissipated by then. But I can tell you that if you have an ipse dixit, one of my favorite Latin phrase, ipse dixit, which means so he says, if you have an ipse dixit declaration that says I will pay into a plan as the father of the debtor $100 in perpetuity, no one attempts to get behind that. They just take it. and accepted as true. Any thoughts on that?
Me personally, I haven't, it wasn't in a conversion, but in a chapter 13, I have used declarations like that were accepted. Yeah.
So let's see what else we've got.
I have a thought on
ahead.
Andy's question as well. I think we have a case that we cite sometimes when debtors try to convert to 13. I think it's from the 1980s that basically says trustees are entitled to quantum merit or something like that when the case converts to 13. So it is like a courtesy thing where will people fight us on it? Because it's typically a consumer attorney that's filing and you don't want to make the trustee too mad. So a lot of the times they'll agree to pay the Chapter 7 trustees' fees and counsel's fees as a claim in the Chapter 13 plan.
I think it depends on the facts. I think it's one thing for a Chapter 7 trustee to be pursuing a case for 3 months as opposed to 3 years. I think it's also going to be probative if the Chapter 7 trustee has been keeping track of her time and has, actual bills. But I can say that certainly any kind of, and it also depends on where the U.S. trustee is at, Tinho. Is the U.S. trustee involved in the case? Have they been working with the Chapter 7 trustee? I think that has something to say. We had a situation, I had a case where the U.S. trustee's office was pursuing a 727, and I represented a trustee, Chapter 7 trustee, and and we were going after an asset. Once the U.S. trustee's office settled with the debtor, we were forced to settle. In other words, you can't have the Chapter 7 trustee keep going and the U.S. trustee settles. And then they helped negotiate my fees, and the Chapter 7 trustee dropped his claim.
So if you have an undisclosed or undervalued asset and the debtor wants to pay the fair market value but needs some time, how much time do you give them as an alternative to a 3 to 5 year repayment plan?
Well, I'm talking about a conversion to Chapter 13. In other words, I'm not going to get into the weeds other than the fact that if it fails, we're going to get it back. But I would never start getting into whether it should be 3 years or 5 years. But typically, whatever they propose has to be better than what we proposed in Chapter 7. And that's usually in the stipulation. In other words, we've, to convert, we fleshed that out. Have you had, Cliff, have you had experience with this?
I had one case that the debtor had to convert because of the value of the assets. And they were able to convert it, and we agreed to pay the Chapter 7 trustees' attorney's fees.
Over time.
Yeah, in the plan. As a priority, though.
$60 a month or something like that. Okay. Let's see, I'm on page 130. Regular payments such as a pension, Social Security, child support qualifies as regular income. Conversion by parties other than by the debtor on page 134. How hard, it's been my experience, and maybe Mike has some experience on this, when a creditor brings a motion to convert in Chapter 11 or Chapter 13, isn't the debtor typically exhausted and doesn't fight? What are your thoughts on that? In other words, after a year or something, Mark, do you have any thoughts on that?
I'm thinking about the last time that happened. Yes, the debtor was exhausted. However, that was part of the debtor's plan to get.
Or her attorneys are exhausted. Same
Yeah.
thing, right?
Yeah, everybody was exhausted in that last case, especially the creditors. Um, the exhaustion came from highly contested relief from stay motion, after which the case was settled and it slipped into a 7 liquidation, and everybody was happy, I guess. But yeah, everybody was exhausted financially.
Okay, let's go to page 135. If the debtor converts the case from chapter 13 to chapter 7, section 348F provides that unless the debtor has made the conversion in bad faith, property of the chapter 7 estate consists of property of the estate as of the date of filing of a petition that remains in the possession of or under the control of the debtor on the date of conversion. Therefore, if the conversion is in bad faith, the date for determining property of the estate is the date of conversion. However, if the debtor did not convert in bad faith, the Chapter 7 estate is confined to the debtor's property at the time of the original filing of the Chapter 13 petition, and does not include any property that the debtor acquired during the course of the Chapter 13 case. So, if there are provisions of a Chapter 13 plan, they might be difficult to unwind. Has anybody had any, by a Chapter 7 trustee, has anybody had any experience with that? Christine?
I have not.
No. Such as valuation. Is a Chapter 7 trust, Tinho, is a Chapter 7 trustee going to have difficulty with valuation if it's been determined, if an asset's been determined in the pendency of the Chapter 13?
Well, it would be market value post-conversion anyways, right?
Not, well, be as of the petition date, which I wanted to bring this up. I seldom see this litigated, that the appreciation goes to the debtor. Has anybody seen that in a converted case? People just let that go. Cliff?
I haven't seen it, but I understand there's a new California statute about post-petition appreciation belonging to, I haven't seen that tested though.
No, neither have I. It seems to be completely ignored, nor have I seen a debtor's attorney bring it up. Although I can tell you any Chapter 7 trustee worth their salt is going to get rid of the assets as quickly as possible. You don't hang around because it's a time bomb. So you want to flip it as quickly as possible. So that statute wouldn't typically arise.
I'll just say
ahead.
the post-petition appreciation thing did become somewhat relevant in the COVID era because, as everyone knows, property values exploded. So we did have a couple of cases that were hanging around for a couple of years, but based on maybe fairness, trustees were like, yeah, technically it hasn't been abandoned, but it would not be fair at the final report stage because it's been hanging around for 2 years to suddenly spring up and sell the debtor's house now that they have won the 170 or the 100, 175 exemption. Now it's worth way more. Like, just wouldn't be fair. Trustees have hearts too.
Is that true? I had a case where a debtor had an Allstate insurance company, and what do you want to say, franchise? And I sold it back to him for 50 grand, but there was no release. And for some matter of fact, this is a Marshak Hayes case. This Tinho, this is your firm's case. You represented me. And about a year later, I got a call from the debtor, and he said, I need you to quit claim your interest in my house. I said, what? Yeah, I need you to, my house is up for sale. I said, well, that's interesting. How much you getting for it? Anyway, we hijacked the sale. Then we sold it. Pretty funny. Okay, moving along. I think that 138 and 139 and 140, 141, 142. And this is the differences among 7, 11, and 13. And I think it's definitely something that you have to be ready for uh, with regards to the exam, because this is going to be tested in terms of debtor comes in. Do we file a 7, 11, or a 13 and explain? Okay, let's start on page 139. An involuntary petition can only be filed in a Chapter 7 or 11 case. Why is that?
13th Amendment.
Because you're not an indentured servant, I guess.
Okay, but funny enough, you can do it in, well, true. So presumably in 11, you're not indentured, right? Presumably. Let's see, the automatic stay only applies in all chapters, but it protects certain co-debtors only in Chapter 13, which is section 1301. Anybody familiar with that statute? Cliff, have you ever applied this?
Yeah, a couple times, I think.
Do you seek sanctions?
No.
A creditor may not act or commence or continue any civil action to collect all or part of a consumer debt of the debtor from any individual who is liable on such debt with the debtor. So what do you just typically send a letter, Cliff, and that does it?
Well, I guess the typical scenario would be, yeah, co-debtor on a mortgage and there's collection activity.
Hey, I've got a question for you. Some of the bigger petition mills that appear before me have now, and we discussed this in a previous class, but it seems to be increasing, which is why I bring it up again. Do you have a side business where you sue debtors for or sue creditors for violating the state?
No.
Have you seen that?
No, I think I might have heard about it, but I haven't seen it.
What you do is you list it in the schedules, and then you claim it as exempt, but trustees don't challenge it. But it seems to be becoming more prevalent. More debtors attorneys seem to be doing it.
I think it's a little bit more popular in other states.
Is it?
Yeah, I think it's my understanding that, the judges here will want to see that you've contacted the creditor with a letter. I've sent out letters before and, warned them.
Wouldn't the
Usually stops at that point.
Go ahead.
wouldn't the damages be a post-petition asset? There's a state violation.
I guess I'm speaking of the ones that are scheduled, which are pre-petition. I guess there was some kind of violation in the Truth in Credit Act or something like that. So
Yeah.
I'm not talking about 362.
Oh, okay.
And I think maybe like Rosenthal Act.
There you
Yeah.
go.
Fair Debt
violation.
Collection Practices Act. Yeah,
Yeah.
exactly.
But you have to, Christy, you have to sue in state court, right?
No, you can just send a mean letter and get some money.
Get some money.
I have done that actually.
Yeah. Well, I have to say it's catching on. All right, moving on down. Let's see.
I'm sorry. Isn't that for like phone call violations and, after the creditor knows that the party is being represented by an attorney, for instance?
I guess stuff like that, yeah.
Yeah.
But how do you
Yeah.
quantify that?
I think it's per phone call and they
It
have
can
to
be
keep
up
a
to
journal.
it can be up to $1,000 per violation.
Oh, so there you go. There's money.
Yeah.
there.
I mean, each time they do it. Each time they
Yeah.
call after you've warned them.
So you have like a call log, right? That's like
Yes.
cha-ching,
Yeah.
cha-ching, cha-ching.
Yes, I have submitted their phone records and said, look how many times you did that after I sent you notification. Yeah.
Right. Okay, in a chapter 13 or a chapter 11 case involving an individual debtor, the estate consists of, I'm sorry, backing up. However, in chapters 7 and 11, the court has the discretion within its general equitable powers under 105 to enjoin action against a co-debtor where appropriate. How many people in this class have ever filed a lawsuit in a chapter 11 for injunctive relief to protect a co-debtor who is not a debtor? Go ahead, Mike.
It was in a chapter 11 and we had to protect the principals until we got a plan confirmed. So it was successful.
And does the judge ask you for progress, or does the judge just let it sit there?
One more time.
In other words, if the TRO is issued, then what happens? Is it just stayed, or does the actual adversary proceeding move along?
It was just stayed.
So it just trails the bankruptcy case.
Correct. At least it did in my case. I don't know how it normally goes.
I guess the problem is that's time consuming for attorneys, right?
We didn't want to do it, but it was necessary in the case. So
All right. Property of the state. In a chapter 7 and chapter 11 case involving a corporation, property of the state consists of the debtor's property at the time of the petition. Post-petition property is generally not part of the estate. In a chapter 13 or a chapter 11 case involving an individual debtor, the estate consists of both the property of the debtor at the time of the petition and post-petition property. So in a chapter 11 case, what are your experiences with regards to the debtor's earnings?
They should be part of the disposable income that should be taken into account, at least in small cases for the plan.
Lady, do you have the debtor, if the debtor's an individual, propose a budget for living expenses that then was approved by the court?
Not necessarily approved by the court, you know, to the discussion at the beginning, it is what it is, and, you know, you lay it out in the.
Do you just use schedules I and J, or do you actually have some form?
I create pro formas based on schedules IMJ for the projections during the life of the plan.
And do you ever during the course of the case go back and look at actuals versus the budget?
With respect to the plan, no.
So long as the plan payments are being made?
Well, okay, so in the subchapter 5 world, things happen very quickly. You know, I'm thinking of a case that I just confirmed that from beginning to end, it was 6 months. And so it was an individual and his wife who were employees. They had a salary, and with expected increases throughout, you know, periodically. So just bake those in, put them in the oven, and voila. Not much argument there. The whole point of subchapter 5 is to get everybody to agree to a plan. And if you show them, you know, this is what the schedules are, here are the W-2s or the tax returns, you know, it's pretty compelling.
Okay. Let's see. Disposition of estate property. In the chapter 7 case, estate property is liquidated and proceeds distributed to creditors. An individual debtor is entitled to claim exemptions in some property under section 522. It may be possible for the debtor to reacquire estate property by redemption under 722 or reaffirmation under 524. Reaffirmation agreements in our district are being increasingly denied. Has anybody noticed that? Any thoughts on that?
Well, it's not surprising because of the new law that allows, you know, retain and pay to which has returned, right? Which you're allowed to just retain and pay again, the drive-through option. So I'm not surprised to hear that.
Why is it that redemption motions are so rare, 722?
I can tell you my opinion because I used to do them, but because the valuations are, it's, unless the car is really upside down, it's not worth doing. Just because the interest rate and the valuation of the car is going to be potentially argued, and it's just financially not viable for the debtor. It's not going to be good unless the car is really, really upside down.
Whether it makes economic sense or not, I've seen automobile financiers oppose 722 motions, even if it's not in their economic interest. Anybody seen that? Mike, yeah? No? So I guess that's another issue, is because it's unusual, you don't know if it's going to work. But I would say, as a Chapter 7 trustee, I see like 2 a year.
Wes,
Go ahead.
I have a comment and a question about reaffirmation agreements with regard to house mortgages. Over the span of my practice, I occasionally get a call from a client who years ago did a bankruptcy and did not reaffirm his mortgage. And he's now trying to refinance, and there are no records that he ever paid his mortgage after the bankruptcy. And that's because the banks don't record that he's making payments if there's no reaffirmation agreement in effect. In order to avoid that, now when there's a mortgage and the client wants to keep his property and reaffirm, how do we, is a reaffirmation agreement going to be denied? Because the debtor actually gets a benefit from signing the reaffirmation agreement, in that the lender will now report that he's been making payments. So if he ever wants to refinance in the future, he won't run into that obstacle.
What does the code say about reaffirmation agreements involving real property?
Not required.
That's, yeah, but I think doesn't it say so?
I don't know, but I know it's not required.
Yeah, they're not required, but they're required by the bank if the bank is going to write down that it goes to the debtor's credit.
May I say something to
Go ahead.
that? Because that happens to me all the time, where I get creditors. I mean, my clients call me up later because they want to refinance, and some company has told them that, oh, you needed to reaffirm. That's not true. There are many banks that will refinance them without it, and that's what I tell them. They are not telling you the truth. Go find another finance company, and I even suggest some to them. I couldn't tell you off the top of my head. I'd have to look, but it's just simply not true.
I have a comment on that too, Christie.
Yeah.
Yeah. That happens about once a month. I've handled, I've been doing this time since I've had hair.
Yeah.
And, they'll tell me, oh, the bank told me, the broker told me that you should have reaffirmed the debt. I'm like, okay, let's get them on the phone, because they're giving bankruptcy advice and they haven't made the proper disclosure, so they can be
Exactly.
sued. So they'll never admit that. But under the Fair Credit Reporting Act, the debtors can put their own notes next to a furnisher's information and say that all post-petition payments have been made on time, and is, quote, current as to the obligation securing the property. And then I do the same thing, Christie. I have a lot of I don't get kickbacks or referrals, but I have a pool of excellent loan brokers that will get the person financed. So never go back to the same lender, because they won't do it.
Exactly.
Because Mark is correct. They do not have to report payments being paid because they're not contractually due, and that obligation has been forgiven. So that's what I've run into.
They can also report to the credit reporting agencies the payments that they have made. So the person, right, can add that to their credit report.
Right next to
And
the
show that, and show that the payments have been made.
So if a creditor on a secured debt stops sending you statements because they think it violates the automatic stay, once the case closes, how do you get the creditor to start issuing the statements again?
There are some companies that will allow, like the attorney, us to sign an authorization to do so, and many that won't. Other than that, I don't know a legal way.
So what, so what does your client do?
They just continue to call and make the payment and ask what their balances are.
So they call over the phone? Is that what you're
Yeah.
saying? Well, that's
Yeah.
well.
It is.
Christy, you might want to take the approach. I've written to banks, there's very few. Everybody will send statements if you as the attorney say that, we don't consider a violation. Write to the lender and say that we expect you to perform your duties by advising the client as to what is owed on the lien obligation, not as to their personal liability under state law. And sometimes,
Okay.
well, that makes sense because the debt is discharged, but there's also a lien obligation. So
Okay.
I've never
Mhm.
had that denied after that. Just,
Okay, good. Good to know. Thank you.
I never had to enforce it, but just FYI.
Okay.
You would think they'd be willing to take the money, but they're not.
Yeah.
Okay. A Chapter 7 case does not affect the debtor's post-petition income, which is part of the debtor's fresh start estate. In cases under Chapter 13, the debtor's disposable post-petition income must be applied to payments under the plan. There is no set rule on post-petition income in a corporate Chapter 11 case. Its allocation to the plan depends on the terms of the plan. However, an individual Chapter 11 debtor must commit disposable post-petition income to the plan. In Chapter 13, if the debtor gets a sizable raise, how does the debtor's counsel treat that? Is there a form you fill out? Or do you just propose an amended plan?
Well, usually I hear from the trustee after they get the tax returns. Because sometimes I don't even know they've gotten a raise, right? At some point, they're just paying into the plan. And then the trustee will ask me to update the income and expenses. And, sometimes they've had to pay more into the plan, and other times the plan remains the same, just depending on their circumstances.
What do you think would be the threshold increase? Like 50%? In other words, 10% nobody cares, 20% no one cares. Or does it
I
depend on-
personally don't know.
You've never encountered that?
I've had somebody double their income, during COVID, and the trustee contacted me and they ended up in a 100% plan.
You don't. I'm on page 140. Let's see. The administration of the estate and the operation of the debtor's business. In a Chapter 7 case, the trustee administers the estate, and if the debtor has a business, conduct short-term business operations. The business is liquidated as soon as possible. In a Chapter 11 case, the debtor in possession assumes the functions of the trustee and operates the business unless there's cause to appoint a trustee. In the Chapter 13 case, a trustee is appointed and performs investigative and supervisory functions. A debtor who has a business continues to operate it under the trustee's supervision, but does not have the status of a debtor in possession. How deep or how much into the weeds does a Chapter 13 trustee get into with regards to the operation of a business in Chapter 13? Does she just ask for proof of insurance, proof of payment of local taxes? I mean, what is the extent of their involvement? Christy?
My only experience is that they want to see profit and loss statements every year, as well as tax returns from the corporation or the business every year.
That's it.
Mhm.
All right. With regards to Chapter 7, almost always, if you're going to operate a business under 721, you have the debtor's cooperation. It is possible to do it without the debtor's cooperation, especially if it's unscheduled. But I think the trustee definitely has to have a plan that he discusses with the U.S. Trustee's office before this gets launched. So
Wes, how many times have you done that in your career?
I'm doing it right now. I've got a laundromat that is unscheduled. And I filed a 721-542 motion because I don't want to take possession of it without the marshals. and I've got a buyer lined up. And you would never do this unless you have a buyer ready. And so you actually have to have, all your ducks in a row. And then you do it. But the beauty of it is that it's unencumbered.
Did you buy forced placed insurance on the laundromat?
My rule is that I don't buy insurance until I get possession. And in my career, no one's ever challenged me on that, but I never buy insurance. Aleda, do you have any thoughts on that? No. Yeah, if I don't have possession of a house, I don't buy insurance for the house. So, of course, if I do have possession, then I use that. There's a trustee, is it out of Michigan, that has this big insurance business selling insurance to trustees. I forget it. But he does very well. I buy insurance through him. Let's see. Conversion of the case by the chapter. In cases under chapter 7 or 13, the debtor has a broad but not absolute right to convert the case to another chapter for which the debtor is eligible. Who do you think converts cases from 13 to 7? Do you think debtors do or attorneys do?
Well, in my experience, it's the debtors.
So that the attorneys don't say this is a dog. This isn't going to work. I don't want to spend my time on this.
Well, typically, I mean, for me, in the cases that I've had to convert, the person's in a chapter 13, there's a change in circumstance and they can no longer, pay the plan payment. Maybe they're unemployed for a while and can't find a job. And, so they come to me and say, hey, I can't pay. And then I determine whether the case would be better off just dismissed or converted.
Okay, and what's usually the answer? Dismissal?
No, I don't know. Sometimes I have two cases that just converted. Both people lost a job, and then I have one that was dismissed.
Whenever I
Because the debtor wanted to be dismissed. They didn't want to go through chapter 7.
Often, at least in my world, chapter 13 conversions to chapter 7 involve cases that are pro se and were just done to get the automatic stay. So my staff is trained to immediately look and see if there's real property in foreclosure the minute we get that notice. And I would say 1 case in 10, there's something there. Let's see, dismissal of the case. A chapter 7 case may be dismissed by the debtor or other party in interest only for cause. In the case of an individual consumer debtor, abuse of the code is cause for dismissal by a creditor or other party in interest. A chapter 11 case may be dismissed by the debtor or another party in interest for cause. In the chapter 13 case, the debtor has a broad but not absolute right to dismiss. With regards to chapter 7, if the chapter 7 trustee uncovers an asset and the debtor wants to just dismiss, that is difficult.
Yeah, that's impossible.
So,
Or, one thing I'd say is the 2 cases that it converted did not have property involved. The case that has property involved, they just dismissed the case.
oh yeah. Okay. I had, if I could just ask you a question. This came up, I'm just asking you, I'm not asking you a legal question, I'm asking you an ethical question. Debtor has a duplex. And it has 2 different addresses. And debtor only puts down 1 address. And assume that they're different APMs. Would that be grounds for a 727 or not?
Are they putting the entire value of the whole property?
Yeah.
No. Whoa. Do they own the whole property?
Yes.
Yeah, I think that would be a problem.
Any other thoughts?
I think there's an issue when the attorney does his due diligence. He has to look at the title records to see how that property is listed with the county.
How often do attorneys do? With all
Well,
due
I do,
respect?
I do it
How
especially
often
with,
the debtors attorneys do that?
well, this was an ethical question, so I think ethically we have a duty to, especially with a
That
duplex.
duplex, yeah.
You know, you want to make sure that, because sometimes owners don't, they think they own both, but they really don't. You know, you're relying on your debtor's interpretation of real property law. I would always go to the title and see.
Yep.
I guess my thought is the debtor is going to say, well, I wrote down my address. What more do you want me to do?
But Wes, isn't there a bigger issue too? I mean, if they only put half the duplex and the other half is rented out, they didn't list the income in Schedule I.
Oh, yeah. Yep. Although often it's family members in there, you know, in the other half. But legalities aside, whenever I'm looking at a 727, I go through what's the story going to be, and who's the judge, you know, and where's this going to go, let's see. Claim classification. I'm on page 141. Apart from the statutory classifications of claims into secured, priority, and general claims, there is no claim classification in the Chapter 7 case. However, in Chapters 11 and 13, the debtor is able to designate classes of creditors in the plan and to treat those classes differently, provided there's a rational base for the classification and the discrimination is fair. Do any of you enjoy doing this? It seems to me this would be the fun part about Chapter 11. Lady, you find that interesting?
Absolutely. This will make or break a case. Yeah.
Anybody else? I think to the extent that there's discrimination, I think judges enjoy deciding those kinds of disputes, getting that briefed and how is this claim different than that claim. Let's see. Creditor, bottom of the page, creditor participation in formulating and voting on a plan. There is no plan in Chapter 7 case, so this is inapplicable. Creditors do not consent. Creditors' consent does not feature in a Chapter 7 distribution. In a Chapter 11 case, creditors are involved in plan formulation, and under some circumstances may even propose a plan in competition with the debtor's plan. Creditors vote on the plan. The debtor needs a prescribed level of creditor approval to get the plan confirmed. In the Chapter 13 case, only the debtor may propose a plan, and creditors do not vote on it. The plan is confirmed if it complies with code requirements. Why is it that creditors don't get to vote in Chapter 13? Too cumbersome? You probably couldn't get these big mortgage companies to vote. They probably would just ignore it. Any thoughts?
It would get really expensive too.
What's
It would
that?
would get really expensive too, you know, if you start having all this litigation in Chapter 13. I mean, isn't that one of the reasons why you have sub 5 now as opposed to regular Chapter 11 to help decrease costs?
Yeah.
Yeah, in a Chapter 13, you have a Chapter 13 trustee monitoring the case. So you don't need as much active participation by creditors.
There you go. There you go. Okay, finally, we're down to discharge on page 142. And does anybody know what a discharge with or a dismissal with prejudice is?
Yeah, it means you can't file again and you got dismissed without a discharge.
Right, but what else does it mean? This is a function of case law. This isn't a function of the code. What is a dismissal with prejudice? It means that the claims are non-dischargeable.
Yeah. Yeah, wow. Because I guess that makes sense, yeah.
Yep. Let's see. A corporation cannot receive a discharge under Chapter 7, but can receive a discharge under Chapter 11. An individual may receive a discharge under all chapters of the code. There are differences as the debts encompassed by the discharge under the different code chapters. And there's also some variation among chapters in the time that the discharge is granted and the basis for denying the discharge or excluding debts. I do have a little more story that I can now tell because I've been successful. I do represent debtors. And I represented a debtor that had 2 failed businesses, and he had $2.5 million in unsecured debt. And I filed bankruptcy for both corporations. Neither were challenged. I filed bankruptcy for him and his wife, and PayPal, which is Swift Financial. Anybody have any experience with them? Yes, you have? What happened?
With PayPal in a chapter 7,
Yeah.
nothing. They just,
Well, they filed a 523 complaint against my
Wow.
clients. So luckily I drew a good judge and I filed a 12B6 motion. And we got into a couple things. They accused them of embezzlement, but just because you have a UCC1 that includes deposit accounts doesn't mean that you have a perfected security interest in bank accounts. There are various procedures that you have to do to control an account. Anyway, the point of my story is this, is I did some research and found extensive cases nationwide, unpublished, where PayPal lost 12B6 motions.
Wow. Good to know.
So I bet you can see which way this is going. So, and then I did a little survey using Pacer of all the cases they had filed in the Central District of California. So on my second, they amended that. I told them not to amend the complaint, but they did. So then I filed another 12B6, and on this one, I asked for a pre-filing order. So I asked the court to enjoin PayPal from ever suing debtors ever again unless they got the permission of the bankruptcy court to do so.
Wow.
The case settled for $10,000.
Nice. Very good.
On that note, I've got some good news. Lucy is about to have another baby.
Oh, wow. Awesome.
So we are going to go on vacation we're going to go dark for 2 months, if that's okay with everybody.
Of course. Yeah.
So we are going to resume with chapter 6 in September. Do you guys have your calendars out?
Yes.
Is everybody free on the 20th?
That's good for me.
no, I've got a conflict. If it works for everybody else, that's fine, but I have a conflict.
Would everybody prefer the 13th, Friday the 13th?
Fine with me.
Is that okay? Notwithstanding that it's Friday the 13th?
It's fine.
Okay.
May I ask one quick question before we go? Sorry, everybody.
Go ahead.
I don't do business bankruptcies, just consumer. And normally when I have consumers come to me with a business, they want to close it and walk away. So we just file a consumer chapter 7 and close the corporation and dissolve it. Why do people file chapter 7s on small businesses if they don't get a discharge?
Rookie mistake.
Okay.
If
Okay.
that's directed to me, I have an answer, but does anybody else have a comment?
I have an answer.
Go ahead.
I'm presently working with Jenny Dolan on a case. It's very popular for creditors now to allege piercing the corporate veil when they sue a corporation or threaten amending a judgment against a corporation. So the filing of the bankruptcy creates a stay and prevents them from doing that.
Okay. So okay.
But isn't that stay only temporary, Mark? And basically, once the case is closed, the creditor could still sue and get a judgment against the corporation.
I'm in Mike's camp. The point is that it ends it.
Yeah.
Maybe not legally, but in terms of paperwork wise.
But if they're gonna file a consumer chapter 7 anyway, then they're protected, right? They don't need to file a business bankruptcy.
Yes, but sometimes they can't file a chapter 7 because they're too
That's why.
Yeah.
Okay, sometimes, okay, got it. Thank you. Okay, that makes sense.
Just
Okay.
as a precautionary tale, got brought into a case. If you get a savvy trustee like Wes and you file a corporate chapter 7 and he pokes around and says, wait a second, I can go after the principal. So I can go after
Yeah,
these preferential transfers.
yeah.
I would say be very cautious before filing a corporate chapter 7. I've had this wonderful arguments with Michael O'Halloran down in San Diego.
Bless him.
But I will tell you, the one time that you absolutely want to file a corporate chapter 7 is if there are priority creditors that are also non-dischargeable to the individuals that will get paid by Wes liquidating those assets and making sure that the proper priorities are paid. Then there's a real benefit to filing that corporate chapter 7. But I would rather almost have somebody pay an assignee and do an ABC and have a friendly assignee go through and take care of the
Okay,
corporation.
makes sense. Thank
But-
you. Thanks, everybody.
Yeah, but
Makes
Christie,
sense.
on the other note too, just make sure that whatever steps and actions your clients have to take with respect to winding down that corporation, they do before they file their chapter 7. That you don't want any post-petition acts alleged by creditors.
Very smart.
So
Okay,
just wind everything up, do the final returns and do the dissolution and then file the 7 for your clients.
okay,
Everything's wrapped up in that equation.
I
very
agree.
smart.
Wes, I have a little bit of a
Right.
follow-up. You were talking about UCCs, and this is something that perplexes me, and I'm seeing a lot of it in what I do. And maybe Alita does, maybe Mike does, but I'm seeing a lot of cases being driven by MCA loans, and I'm looking and monitoring what, gosh, I'm blanking on his name, but there's someone in the Central District that does this type of litigation. And I'd really love to learn a lot more about what you were talking about, the validity of the UCC and how you attack those. And I don't know how that plays into your schedule, but it seems to be a really common thing coming up, and I'd like to learn how to address them.
If you send me an email, we can include that as a topic with chapter 6 next class.
Okay.
Okay,
Wes,
Thank you, everyone. Congratulations to Lucy.
Wes,
Yeah.
one final question.
go ahead.
Are the certifications for continuing education going out?
They are, Lucy's gonna push them out today.
Oh, okay, good.
Okay.
Also, Wes, can you send us the information on the PayPal case that you had?
Let's see, yeah,
Case number?
I shall. Bye-bye.
Thank you.
Have a nice summer.
Thank you. Thank you.
Happy summer, everyone.
Happy summer.